Hi, I'm Palmer Johnson. I'm a divorce attorney in northeastern Oklahoma, and welcome to my video series where I discuss frequently asked questions I get from my family law clients. And today's question is, or topic, I should say, is what I'm going to call the trap of the protective order, or the question of, should I get a protective order? I think I've got the grounds to do it, and I've heard that will give me an advantage in the proceedings. So, to that question, which I do get from time to time, what I usually say is, well, let's think twice about this. Let's really look at it. I'm never going to advise a client they should not seek an order of protection in a situation where they truly need it, where they're absolutely afraid of the other side. Um, there are real risks here and disturbing behavior that would absolutely rise to the level of yes, we should get a protective order. Then there's this whole other category of client that they're not really afraid. The other side's done some nasty things to them. They've made some threats. Maybe it's even in writing, because that's oftentimes a real important thing is that we can prove it. So maybe it's in text messages or a voicemail. And on its face, or taken just as it is, would would most likely reach the level required at least at the first stage to obtain the emergency ex parte emergent protective order, which is basically going to be granted on the face of the pleadings if you've met the statutory requirements. So, but here's why I'm saying think twice about that, and think twice about whether or not it actually gives you an advantage in the proceeding, because oftentimes people will include the kids on that. Then you go and you file your petition for divorce. You've got the protective order. At the end, the other side gets served with it, and at the initial proceeding on the protective order, it's immediately consolidated into the divorce matter, which tends to create a scenario where the protective order sort of just sits there, and they go both directions, meaning you can't speak to the other side, they can't speak to you. It creates this barrier that prevents a lot of things from progressing in a case, and it just sort of starts everything on high center, and it many times spurs the other side to immediately go and get a protective order too. So then you've got two competing protective orders in a divorce case, and they're, you know, and they just sort of end up trailing along in the divorce case, and what happens is they ultimately get dismissed at the end. But what they've had the true effect of doing, in my opinion, is um, making the proceedings far more expensive, far more acrimonious, far more difficult for the children, far more difficult for both of the parties involved, and cost both parties a lot more money to get to most likely the same outcome. So what I'm saying is don't confuse anger and hostility at the initial stage of a divorce for a need for a protective order when you um, know that you well and truly don't, and you simply are seeking it because you think it's going to give you a procedural advantage. I think at the end of the day, in most cases, it really doesn't. I and I think in the worst case scenario, it simply is a tool that a potential alienating parent would use to try to keep the other child away from the children, a tool to use to justify their own thoughts and biases against the other party, and may absolutely not be in the best interest of their children if they're involved in the case. So I think it's something that you'd have to talk to your attorney about, but whether or not a protective order is right for you is going to be a decision that you're going to have to make on a case-by-case basis. And I certainly am not advising people to never seek a protective order. I absolutely think there's a place for them and an appropriate time to seek them. If you've got questions about how a protective order might affect your divorce or child custody matter, please reach out to me at moms.law.